Welcome to Deep Dive. Today we're plunging into, well, what feels like a constantly shifting target, the U.S. immigration landscape in 2025. It's complex, to say the least.
Oh, absolutely. And separating fact from fiction is more critical than ever this year. 2025 has brought some really major shifts. We're seeing stricter visa processing, new, frankly, astronomical fees in some cases, and much tighter documentation checks across the board.
Yeah.
The room for error for applicants, it shrunk considerably.
That's the absolute truth. And, misinformation isn't just confusing. It can actually derail perfectly legitimate plans, professional, academic. It can lead to losing status or serious financial hits. So for you, our listener, our mission today is really to be your guys. We want to pull out the facts you need right now about H-1Bs, green cards, student visas. We're going to try and quickly but thoroughly debunk, let's say, 10 of the stickiest misconceptions that seem to be floating around.
Sounds good. And we've grouped these persistent myths into three main areas. Let's start with maybe the most immediate challenge for many, getting and keeping a skilled work visa.
Okay, let's unpack this. First up, a really loud rumor, myth one, that the U.S. has just completely stopped issuing H-1B visas for skilled workers. Like the door slammed shut.
Yeah, I hear that one a lot. It's fascinating how a process becoming more difficult gets twisted into a complete ban. The reality is, H-1B visas are still being issued. They absolutely are. But the rules are dramatically tougher.
Okay.
The system is working, but, well, the hurdles are higher. And the biggest point of confusion and maybe financial shock right now is around the new fee structure.
Right. Let's nail down that specific detail because it sounds, well, shocking, that new $100,000 filing fee. It sounds like it would stop most companies cold.
It's a massive change, no doubt.
Yeah.
But it's really important to understand who pays it and why. This fee isn't for every application. It's typically targeted at specific categories of larger companies, often called H-1B dependent employers.
Okay, the ones who rely heavily on foreign talent.
Exactly. The thinking behind it is to, well, discourage over-reliance on the program and maybe push for higher wages for everyone, American and foreign workers. The crucial point, though, is that employers can still sponsor professionals who meet the wage and education requirements. It's just that the financial barrier for certain companies is now unprecedented.
Okay, that makes more sense. It's regulating how it's used, not actually banning the visa itself. Let's shift to another common one, especially for international students who've, invested a lot in a U.S. education. Myth 2, that getting a U.S. master's degree basically guarantees you an H-1B visa.
Oh, definitely hear this assumption often. Like the degree is some kind of golden ticket, you just bypass the whole lottery thing. And while yes, an advanced degree does improve your odds significantly, it absolutely does not guarantee selection. No guarantee.
So what's the actual mechanism? How does it make the odds better, but, not certain?
It basically comes down to getting two shots at it. Applicants with a U.S. master's or higher get put into a separate pool first. There are 20,000 extra lottery slots just for them.
Oh, okay.
So they run that master's cap lottery first. If you're not selected there, then your petition gets rolled into the general lottery with everyone else. So two chances. But, and this is the key part, when the demand just completely swamps the annual cap, which it almost always does,
right,
well, the whole thing still ends up being a random selection process.
Right.
It's definitely an advantage, a real one, but certainty, that's just not in the H-1B dictionary right now.
That's a really good clarification. Now, let's say someone successfully navigates all that and gets to the H-1B. There's often an assumption of total freedom after that. Myth 3. H-1B workers can just change jobs whenever they feel like it, just like a U.S. citizen.
This one is maybe the most dangerous myth out there. Because acting on this assumption, it immediately puts the worker out of legal status.
Wow.
The fact is, job mobility requires mandatory legal steps. The H-1B visa is tied specifically to the employer who filed the petition and got it approved.
So what's the absolute required process? What do they have to do for a transfer?
The H-1B holder can only switch jobs after the new company files a specific H-1B transfer petition with USCIS. Now, there's something called H-1B portability, which means they can often start working for the new company once that petition is filed. They don't always have to wait for approval. But that initial filing must happen correctly.
Okay.
Leaving the old job before that new filing is confirmed, you're instantly out of status. Done. That paperwork, that timely filing, it's literally their lifeline in the U.S.
All right, let's move beyond the initial work visa hurdle. Let's talk about the path to permanent residency, the green card, and eventually citizenship. This whole area seems defined by, well, frustration over waiting times and where you're from. So, myth 4. Green cards just aren't being issued anymore for people from high-demand countries like India or China because the backlog is basically infinite.
Yeah, the infinite backlog idea, it certainly feels that way to many people, understandably. But factually, they are still being issued. The system is processing applications every single day. The wait, however, is, well, it's excruciatingly long. That part is true, and it's driven entirely by the per-country limits set in U.S. law.
Right. So the law caps the number of employment-based green cards for any single country each year.
Exactly.
So if you're from a country with a huge number of people applying, you just get stuck in this massive queue because the limit's the same for you as for a country with hardly any applicants.
Precisely. You hit the nail on the head. Countries like India and China, they generate enormous demand.
Yeah.
So they end up with these multi-year, sometimes decade-plus backlogs for certain categories.
Crazy dates. Wow.
Yeah. Meanwhile, someone from a lower demand country, the exact same qualifications, might get their green card in, say, a year or two. But the person from India or China, they could be waiting 10 years or more, purely because of their country of birth. It is. And that's why checking the official U.S. Department of State visa bulletin is absolutely essential. It tells you exactly how slowly or quickly that line is moving for your category and country.
Really puts the whole global immigration policy puzzle into perspective. Okay, shifting to family paths. Myth 5. Marrying a U.S. citizen guarantees you instant citizenship. Like, you get married, boom, you're a citizen.
Ah, the instant citizenship myth. A classic confusion between getting residency and getting citizenship. They are very different things. Marriage makes you eligible to apply for a green card that's lawful permanent residency. It's not automatic citizenship, not even close.
Okay.
And the government looks very closely to make sure it's a bona fide marriage, a real one, not just for immigration purposes. The whole process has multiple steps.
And even once they get the green card, what's the sort of minimum time before they can even think about applying for citizenship?
Generally, the spouse needs to hold that green card, that lawful permanent residency, for 3 years. And they need to still be married and living together with the U.S. citizen spouse during that time.
3 years minimum.
3 years minimum before they can even apply for naturalization, which is the actual process to become a citizen. And that application itself takes more time to process. So yeah, instant is basically the exact opposite of reality here.
Definitely not instant. Got it. Okay, last one in this segment. Let's talk about the money route. Myth 6. You can just buy U.S. citizenship if you invest enough money.
Right, the idea you can just write a big check for a passport. Again, investment is a path, a real one, but it leads to a green card first, never directly to citizenship. We're talking mainly about the EB-5 investor program here.
EB-5.
This program requires a pretty substantial investment. Right now, the minimum is usually $800,000, sometimes more depending on the location, and it has to be invested in a U.S. business that creates a certain number of jobs for U.S. workers.
And what status does that huge financial commitment actually get you right away?
It gets you conditional permanent residency first. Think of it as a temporary 2-year green card. Yes. After about 2 years, you have to file another application to prove that you actually made the investment as promised and, crucially, that the required jobs were created. If that's approved, then the conditions are removed and you get the full, regular 10-year green card.
Okay, so even with the money, there are steps and checks.
Absolutely. And only after holding that permanent green card, typically for 5 years of continuous residency, can the investor then apply for naturalization, for citizenship. So, bottom line, no amount of money buys you instant or direct citizenship. It buys you a path to residency, which might lead to citizenship years later.
All right, moving on. Let's talk about the risks involved in trying to switch statuses, especially from temporary ones. Myth 7. You can easily convert a tourist visa, like a B1, B2, into a work visa once you're already inside the U.S.
The tourist to work switch. Okay, so technically, legally, are there narrow circumstances where someone might change status from visitor to something else? Yes. But is it easy? Absolutely not. Is it highly restricted? Yes. Is it extremely risky? Definitely.
Why so risky? What's the main danger?
It really boils down to intent. When you enter the U.S. on a visitor visa, you are telling the border officer your intent is temporary tourism, visiting family, maybe short business meetings. That's what the visa is for.
Okay.
If immigration officials later believe that when you entered, you actually had a preconceived intent, meaning you were already planning to find work and stay intent, they see that as misrepresentation, basically lying to get in.
And that's a big deal, right? Misrepresentation.
Oh, huge.
Right.
Misusing that visitor status, especially if they think you came specifically looking for a job, can lead to really severe consequences. Your current application could be denied, sure, but it could also lead to future visa denials or even bans on re-entering the U.S. for years, maybe permanently.
Wow.
It makes any future legitimate attempt to immigrate incredibly difficult. Your actions need to match the intent allowed by the visa you hold. That's crucial.
That focus on intent is key. Okay, let's talk about students. F1 visas. There are common misunderstandings about work rules too. Myth 8. F1 students can just work full-time off campus whenever they want to help pay for tuition and living costs.
That's completely false. And honestly, acting on that belief is probably the fastest way for an international student to lose their legal status in the U.S.
Okay, so what are the rules?
Work for F1 students is very strictly limited, and it absolutely must be authorized beforehand, usually by their school's designated official and sometimes USCIS. During the school year, generally, they're limited to working no more than 20 hours per week and typically only on campus.
20 hours on campus only. So how can they legally work off campus? I know many do internships and things.
Right. That requires specific authorization under programs linked to their studies. The main ones are OPT optional practical training, which is usually post-graduation work related to their major, and CPT curricular practical training, which is work, like an internship, that's an integral part of their curriculum before graduation.
OPT and CPT.
Both require going through a formal authorization process with their school's international student office before they can start any off-campus work. Working off-campus without that specific authorization, even for a day, it's considered unauthorized employment.
And what happens then?
It automatically terminates their SEVIS status.
Wait, let's clarify that quickly. What exactly is SEVIS status and why is terminating it so bad?
SEVIS stands for the Student and Exchange Visitor Information System. It's basically the U.S. government's tracking system for all international students and exchange visitors. Your SEVIS record is your official proof that you're maintaining your student status.
So it's like your official student ID with the government.
Exactly. If your SEVIS record gets terminated, say, for working without authorization, you lose your legal right to be in the U.S. as a student. You're considered out of status.
And then?
You're typically required to leave the United States immediately. And it usually creates major problems if you ever want to apply for another U.S. visa in the future. Keeping that SEVIS record active and clean is absolutely vital. It's their lifeline here.
A really critical point for every international student listening. Okay, let's switch to job security, or maybe the lack of it. Myth 9. People on H-1B visas, or even those with green cards, can't be laid off because their legal status depends on their job.
Yeah, that's a common hope, but unfortunately it's just not true. Your immigration status gives you zero protection against getting laid off. Companies can, and do, terminate foreign national employees just like they terminate U.S. workers if business needs dictated.
But the consequences of getting laid off are very different depending on your status.
Drastically different. Let's take the H-1B worker first, because the situation there is much more urgent.
Okay.
If an H-1B worker gets terminated, they have only a 60-day grace period. 60 days.
Just 2 months.
Exactly. 2 months to do one of a few things. Find a new employer willing to sponsor them and file a new H-1B petition, or maybe file to change to a different visa status if they're eligible, or pack up and leave the U.S.
Wow, that clock starts ticking immediately.
The day after their last day of employment. That 60-day window is incredibly short and creates immense stress and, frankly, logistical terror for people caught in that situation.
I can only imagine. And for green card holders.
It's different for them. If a green card holder gets laid off, they keep their lawful permanent resident status. Losing their job doesn't affect their right to live and work in the U.S. They're secure in their residency, just not in that particular job. They can look for a new job without that same urgent immigration deadline hanging over them.
Okay, that's a huge difference. That 60-day H-1B window really highlights how temporary that status can feel. All right, finally, let's touch on protections for vulnerable populations. Myth 10. The U.S. has just completely closed its doors to anyone seeking asylum or refugee status.
This is another area where policy changes and rhetoric can create a perception that's not entirely accurate. The fact is, the U.S. asylum system does remain active. It's operational. Is it operating under much tighter scrutiny and facing significant backlogs and policy shifts in 2025? Yes, absolutely.
So it's harder, but not closed.
Yes, exactly. The fundamental requirement hasn't changed. Applicants must demonstrate a credible fear of persecution in their home country based on specific grounds like race, religion, nationality, political opinion, or membership in a particular social group. Now, new rules and stricter enforcement might mean lower approval rates, or perhaps faster processing and removal for those who don't meet the standard. But the system itself is still accepting and processing new claims. The door for asylum isn't welded shut, but the path through it is narrow and the standards are applied very rigidly. #tag outro. So, okay, we've gone through these 10 myths. If we try to synthesize this, what does it all really mean for someone navigating this in 2025? I think the main theme is this. U.S. immigration is still open. Opportunities exist for skilled workers, students, families, investors. And it's a big site. But the system is intensely regulated. It's characterized by complexity, often high cost, potentially very long waits because of specific policies like per country limits, and basically zero tolerance for mistakes or misrepresentation.
Yeah, that complexity and regulations seem to be the constants, and misinformation just makes it all so much harder, acting like the biggest threat. So, the absolutely critical advice for you, the applicant listening, has to be stay relentlessly informed. And you have to rely only on official U.S. government channels. We mean official websites and documents from places like U.S. Citizenship and Immigration Services, USCIS, or the U.S. Department of State, especially their visa bulletin, to track those green card backlogs. And the Department of Labor for work-related rules.
Definitely. Relying on, anecdotes from forums or what happened to your friend's cousin who got lucky 5 years ago, it's just dangerously insufficient now. You absolutely must understand things like that tight 60-day clock for H-1B layoffs. You need to grasp why per-country limits cause those decade-long waits for green cards from certain countries. And you need to recognize that pretty much any path, whether it's through marriage, getting an advanced degree, or making a huge investment grants residency first. Citizenship only comes potentially years down the line after meeting more requirements. Just knowing the actual current rules is absolutely essential for having any chance of success in 2025.
That's an excellent summary. We really hope this deep dive helps you cut through some of the noise and navigate this landscape with a bit more clarity and confidence.
All the best, and we will meet again with another important matter again.